Al's just done a really great video over An Art of Law on how the sub-postmasters were on the back foot from the beginning, because the rules of evidence and procedure for the prosecutions meant that computers were trusted without any rebuttal. So I'll leave more on that discussion for Al, and I'll link that video in the description below, but it did set me up quite conveniently to do a further video on the rules of disclosure, specifically primary disclosure and secondary disclosure, and what those mean. So first of all, welcome back if you're new to me. I'm Daniel Smith, a barrister of England and Wales. I do enjoy helping you to understand law, so please do hit that subscribe button if these videos are useful to you. And just as a heads up, I do have a partner for this video, which is NordVPN, but more about them a little bit later. So what do we mean by disclosure? Well, whether it's a criminal prosecution or a civil claim in the county court or the high court, each party have what we call disclosure obligations. The disclosure obligations essentially mean that they need to give each other certain documents or tell each other about certain documents, either that are in their control or that they know that exist and are not in their control, that may affect the case. The reason for this is that the court, which includes the jury in a Crown Court prosecution, ultimately seeks to find the truth of the matter. That's what the justice system is there to do. And in order to do that, we need the evidence. As you'll recall from previous videos, juries take an oath to find either guilty or not guilty according to the evidence, and only according to the evidence, not according to their own views or something they heard on the news. In fact, they're not supposed to look at the news, and they're not supposed to research these things. They are supposed to look at the evidence. Much like in a civil case, the judge will look at the evidence, and each party have to disclose to each other what evidence they might have that either assists or undermines their own case. Now, it's never stronger than in a prosecution because, as we often say, if we're going to prosecute and then punish somebody, we'd better be right. So the evidence that either underpins or undermines the case against an accused is of paramount importance. So then we get what we call disclosure in the criminal trials, which is primarily governed under the Criminal Procedure and Investigations Act of 1996. Now, first of all, we have what we call the initial duty upon a prosecutor to disclose. Under Section 3 of the Criminal Procedure and Investigations Act 1996, the prosecutor must disclose to the accused any prosecution material which has not previously been disclosed to the accused, which might, and here's the legal test, reasonably be considered of capable of undermining the case for the prosecution against the accused or assisting the case of the accused. In other words, if it's something that would make the prosecution case weaker, then they need to disclose it. And if it's something that would assist the defense in defending the case against them, they need to disclose that as well. The timing required for this initial disclosure is somewhat complicated, but the Attorney General guidelines is that it should occur before the first hearing, which should be possible if it's on a full code test and a not guilty plea is anticipated. But in any event, it should be as soon as possible after a not guilty plea is entered. But that's not the end of the matter, and on this channel it rarely is, because disclosure is an ongoing obligation. That's when we come into secondary disclosure. So there is also a burden of disclosure on the defense as well. That is mandatory in the Crown Court, not quite so mandatory in the Magistrates' Court, i.e. there is no obligation to serve what we call a defense case statement, which essentially sets out the broad nature of the defense, any witnesses they rely upon, why they say they are not guilty of the offence and the real circumstances surrounding the events and so on. If they do serve one in the Magistrates' Court, it should be within 14 days, and it is mandatory in the Crown Court. Failure to do so, as many choose not to, perhaps more about the reasoning why in another video, but some choose not to, but if they don't, then it might affect the evidence they can call later on, and of course it will result in an adverse inference. In other words, that means the prosecutor will tell the jury that they chose not to file a defense case statement, and they might just have less reliability placed upon what they say in court at a later stage. However, all that aside, and perhaps addressed in another video, when the defense does file a defense case statement, that can potentially trigger further disclosure requirements by the prosecution. That being, if the defense case statement from an accused says, well, actually, this is what really happened, or this is why I think I'm not guilty of this offence. So, for example, in these post office prosecutions, if the accused were to say, well, actually, the software was full of bugs. We reported this on numerous occasions. We told them that these bugs were there and that they were misreporting fictitious losses, and all of this is a complete nonsense and we shouldn't be prosecuted in the first place. All of this, if going back to the prosecution by way of a defense case statement, the prosecutors should then be looking at any evidence that might undermine the prosecution case based on what the defendants have said, or assist the defence, again, based on what they've said. Now, of course, if the prosecutor were then aware of some evidence, for example, a chunk of a witness statement or an expert report, or as Al's discussed on his video, even draft reports before the finalised versions, and we're not just talking about typos and spelling corrections here. We're talking about chunks of a report that might have been altered because previous versions of a report might have referred to bugs that could have explained why there were these losses on the face of it that the defendant is accused of being responsible for. However, if in their statement they say they're not guilty of the offence because there were bugs in the system to which these reports or witness statements had previously referred, the prosecutor is under an obligation under disclosure requirements to disclose those documents to the defence, which they could then in turn raise in front of a jury and say, see, these are the documents upon which my story is essentially proven, and I should be found not guilty. However, there is a fairly shocking turn of events where some of this information appears to have been removed from a draft statement, which Al will talk to you about in his video. So I will link that below, and you need to go and watch that because it's rather damning to say the least. But essentially, after the defence has answered the case in its defence case statement, this triggers a secondary disclosure process by the prosecution. Based on all of the information provided in the defence case statement, the prosecution is under an obligation to review all of the material and to identify and disclose any additional evidence which may not have been referred before that could undermine the prosecution case or assist the defence. Because as I say, this is an ongoing duty of disclosure and the test remains the same. Anything that is reasonably capable of undermining the prosecution case or assisting the defence must at all times be disclosed. Now, it goes without saying that failure on the part of the prosecution to comply with its disclosure obligations could not only result in perverse verdicts, such as somebody being found guilty when they really ought not to have been found guilty, pleading guilty on an agreed plea basis when they really need not have done so because they might not have pleaded guilty had they been given the full evidence. It could mean that the prosecution case collapses before it gets all the way through trial because it would be impossible to have a fair trial. And of course, it could mean that on appeal, convictions could be overturned because they didn't have the correct evidence in the first place, not to mention the damage to public confidence in the criminal justice system. There are also, dare I say it, professional and regulatory consequences for legal practitioners if they fail in their disclosure obligations, or if they are caught up in, let's call it, wrongdoing with regard to the disclosure process for something that might harm their case. And finally, it might result in judicial reviews and inquiries into the whole process, much like we have now. And as Al has discussed in his video, it already appears that the Post Office is failing in its disclosure obligations in the inquiry, which is looking into its failures into its disclosure obligations. Now, if all that isn't too much, there is also an aspect which might make this whole situation 10 times worse. But before that, a quick word about my partner for this video and how it might help you. Now, as I mentioned earlier, I have a partner for this video, which is NordVPN, and the services that they provide overlap a great deal with the story that we've been talking about here with the Post Office. That being people having their lives devastated by having to repay money that they felt that they didn't owe. Now, such is the case with many clients that have come to us because they've had their identities stolen and they've then since had to repay money that they didn't actually borrow, but the lending companies believe that they did because someone somehow has taken out a loan in their name, and these people have then been chased to pay it back. The way that this has happened is that they've had bits of their information stolen whilst they've been on unsecured Wi-Fi networks and things of that nature. So NordVPN is a virtual private network, a simple bit of software that you put onto your phone, your iPad, and your computers so that you connect securely to the internet and all of the traffic is encrypted, so that no one in the middle can get hold of that information, steal your information, and then ultimately steal your identity. In addition to that, in recent months, there's been more instances than ever of people receiving text messages, emails, and other notifications asking them to click links and provide their information, all of which is assisting scammers to steal your identity. But NordVPN will help to protect you from malicious websites and having your data stolen in that way. One of the questions from one of you guys the last time I talked about NordVPN is whether or not there are any logs or records of everything you do online and websites you visit whilst using NordVPN. And the simple answer to that is no. Nord does not keep or store any logs, and everything you do online through the VPN is anonymized and encrypted. And albeit a long-term partner to my channel here, I use NordVPN for a long time with my own money way before partnering with Nord on this channel. So you'll find an exclusive discount by using the link in the description below, which, by the way, if you visit, it will show you whether or not your system is secure, because if your IP address is visible to the outside world, that website will show you your location and show you that your system is not protected. So visit the link, check that out, and for just a few pounds, you can have peace of mind. So thank you for allowing me the time, and now back to the video. Now, coming back, as promised, this whole situation with the post office could be 10 times worse than anybody realizes. As discussed with Patrick Green, King's Counsel, with GB News, where he successfully defended 550 private prosecutions by the post office against sub-postmasters in 2019, where he said if you do the maths, with only 69 being convicted and 550 being successfully defended, the real number could easily be 4,000 or 5,000, and that is only based on the cases that he himself represented. Now, what makes this even worse than that, if not just the numbers, is the way that these prosecutions worked and the pressure that they put on people's lives. Because Patrick Green, KC, compared these prosecutions directly with a county court case, many of which I've worked on and one of which even this morning. With county court cases, civil cases, you win or you lose, and you either pay the other person the money, or you do or don't do the thing that the claim was for, and you might pay some costs. But in these cases, they were prosecutions. And he says that the post office used their prosecutorial powers, saying, "I'm prosecuting you for theft." They would respond and say, "Well, I've never stolen anything." They would come back to say, "Well, if you admit to false accounting, then you might not go to jail." But they still get a successful prosecution because false accounting is a dishonesty offence. So when you put people in these situations where they are being prosecuted for a dishonesty offence that's going to upturn their life if they defend it, if they are offered something which appears on the face of it to be a slightly less severe alternative, but still a guilty plea nonetheless, they might well take it, even though they really shouldn't have done. Because as this whole system has unraveled, this IT system was full of bugs and problems and really ought not to have been trusted in the first place. But coming full circle, and to plug Al's video once again, which I'll link in the description below, is these computer systems were trusted without any serious rebuttal. And essentially this means that hundreds of people were convicted when they shouldn't have been. And all of this before we get onto the moral obligations of both the post office and indeed Fujitsu, the software company, which we'll come back to now in another video. So do make sure you subscribe for that one. There's a lot more to talk about yet. But I hope you found this interesting. Please do remember to check out my partner for this video, NordVPN, to protect your privacy online, because with my discount in the description below, you can protect yourself from malicious websites and software and remain anonymous. So thank you for watching, and I'll see you next time.